And Mr. Gaziano, you're now recognized for 5 minutes, sir.
Good morning, Mr. Chairman and other distinguished members of the subcommittee. I'm privileged to be part of the Pacific Legal Foundation that represents Matt Sissel in his constitutional challenge to the Obamacare's individual mandate. And I'm struck by the fact that Mr. Onik suggests that the court should not be involved in that challenge. Yet the ranking member in his opening suggests that this House should not be involved in inquiring about this matter. If asked, I'd be delighted to explain more in questioning why both the House and the courts need to be involved. And I'll use the Chadha case as an important proof that our individual liberty insists that all branches of the federal government enforce our fundamental rights. But let me begin this morning with the following hypothetical. A future House impeaches the Attorney General, let's say for perjury before this body. The Senate then takes up that impeachment article and through a very creative substitute tries and convicts a future Justice Richard Epstein of multiple counts of bribery and other high crimes. My question is, could this House ratify that conviction and remove Justice Epstein by passing a conforming article of impeachment after the Senate trial? Well, of course not. The impeachment of a particular officer must originate in this House, and the subsequent Senate trial must be limited to those counts and articles that originated in the House. But why is that so? Didn't the 17th Amendment change the nature of the Senate? Why should the world's most deliberative body over there in the Senate be confined to only hearing trials or trying impeachment on those people that this House first originated and on those counts that this House originated? Isn't Justice Epstein's trial germane to the articles of impeachment on the Attorney General? Both are officers. Both committed high crimes. What could be more germane than that? And didn't the need of the Senate to remove that loudmouth justice justify this little legislative jujitsu? Let's suppose this. Let's suppose that the House backdates the articles of impeachment after the Senate trial. Wouldn't that take care of all the formalities involved? Surely no one outside Congress could complain. Well, if we think that the future Justice Richard Epstein, who's my friend and hopefully won't mind me using his name, would have a strong constitutional, a winning constitutional claim to keep his seat, my question then is, why do modern thinkers treat the Origination Clause requirements differently? There could be several reasons for that, but I suspect one of them is a lack of reverence for the fundamental liberty protected by the Origination Clause. This hearing and the Sissel case will help resolve whether that important check on our individual liberty can endure. Boiled down to one sentence, the only part of the Senate health care bill and its 17 or so historically large taxes in a 2,074-page bill that originated in the House was the bill number. Putting other grounds for striking that down aside, one fact should convince us that that was invalid. The use of such House bill designations did not exist at the time of the framing or for 30 years thereafter. Thus, the argument that it could be a constitutional amendment to strip everything out of a bill and just leave that number that didn't exist at the time of the framing could not possibly have had any consequence to the framers who ratified it must be wrong. An amendment may improve or augment the original, but it must retain some substantial portion of the original, and as my fellow panelist has already testified, the framers discussed that and agreed. But ordinary English speakers, then in the 18th century or now, would not think that a complete destruction of a house and the erection of a skyscraper on the same street address was an amendment to the House. They would not think that a novel with a particular card catalog number was an amendment for an earlier math workbook that used to have that card catalog number. Complete and unrelated substitutes are not amendments in any reasonable sense of the word. The chairman's point in his opening is absolutely critical and dispositive. If the Senate had to wait for a House bill, only had to wait for a House bill, let's even call it a revenue bill. It wasn't in the case that we're talking about in the D.C. Circuit. They could constitutionally pull, and if they could then constitutionally pour any tax or 17 taxes or historic taxes in a 2074-page bill, then there's nothing left of the Origination Clause. And constructions of constitutional clauses that render empty any particular clause that was debated at the time of the framing are an insult to the framing generation and any rational legal system. I'm going to summarize here since I think I'm over, but if questions permit, I'd like to go to the ultimate question of how we also understand the term originate in the context of the Origination Clause. In the Sissel case, though, the Senate health care bill, with all its historic taxes, had nothing to do with the House bill for service members that lowered their taxes. As such, it was unconstitutional. Thank you.